microphone's off. Pat, your microphone's off. There you go.
Tube, Your Honor.
Okay, good morning, ladies and gentlemen. Welcome back to County Court at Law number 6 and the Bexar County Veterans Treatment Court. Today is our motion to revoke probation docket. It is Wednesday, the 8th of December, 2021. It is approximately 10:25 a.m. The cases I have set for hearing today are cause number 638-793 and 672-980, State of Texas versus Gene Mooney, represented by Mr. Edward Brovenick. And my understanding is Mr. Brovenick is stuck in other courts at this time. Is that accurate?
I believe that's correct, Your Honor.
Cause number 347-834, State of Texas versus Margaret De La Cruz, represented by Mr. Andrew Froelich.
Judge, I'm here. They brought the wrong Margaret De La Cruz down, so whenever she arrives, we'll
all right. Thank you, Andrew. Cause number 628-043, State of Texas versus Andrew Lideker, represented by Mr. Charles Butcher. Cause 657-492, State of Texas versus Cedric Sanchez, represented by Mr. Sean Farmer. Cause number 652-949, State of Texas versus Christopher Bowie. Is that Bowe or Bowie, Mr. Porter? How do you pronounce your client's name?
Judge, good morning, sir. It's Christopher Bowe.
Bowe, thank you. Represented by Mr. Trey Porter. And cause number 660-911, State of Texas versus Matica Jackson, represented by Mr. David Volk. My understanding is at this time, Mr. Mooney and Ms. De La Cruz are not ready, but Mr. Lideker, Sanchez, Bowe, and Jackson are all ready. Is that correct, Pat?
You're muted.
I'm muted?
No, that is.
Your Honor, all the defendants that are on bond are ready. So you
Okay.
go on those.
Let's start with Mr. Lideker. Mr. Butcher, are you ready to proceed?
Yes, Judge.
This is cause 628-043, State of Texas versus Andrew Lideker. This is a first amended motion to revoke community supervision. Representing the state of Mr. Ross Lewis and Mr. Eddie Villarreal, representing the Bexar County CSCD, is Ms. Susan Gross, who I will swear at this time. Please raise your right hand. Ms. Gross, do you swear the testimony we're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. The first document we need to look at on Mr. Lideker's case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, that purports to have both Mr. Lideker's and Mr. Butcher's signature on it. In fact, Mr. Lideker, is this your signature on this document, sir?
Yes, sir, it is.
Thank you. And Mr. Butcher, as attorney for Mr. Lideker, is this also your signature on this document?
Yes, Judge.
Administratively, Pat, I do not have a date at the bottom of this document for the signatures of the defendant and his attorney. If you would ensure that that date is down as December 8th, 2021.
Yes, sir.
And the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Lideker, is this your signature on this document also, sir?
Yes, Your Honor.
And Mr. Butcher, as attorney for Mr. Lideker, is this also your signature on this document?
Yes, Judge, it is.
Mr. Butcher, my understanding is this is an uncontested first amended motion to revoke community supervision. Is that correct?
Yes, we're true.
All right, fair enough. Mr. Lideker, on cause 628-043 on the first amended motion to revoke community supervision, how do you plead, sir?
I have Mr. Butcher.
Yes, the document, he's pleading true on the other line.
Court accepts a plea of true with an explanation. Is that okay?
Correct.
Yes,
All
sir.
good. All right, Ms. Gross, would you please advise the court and the parties of the status of Mr. Lideker? And anybody that is not a foreboding of what's going to happen today. If anybody is not specifically talking to me at this time, please turn your microphone off so we don't get that background noise. Thank you.
Okay, yes,
go
Your
ahead.
Honor.
Yeah.
His reporting has been good. We last saw him on November 19th, 2021. He's paid $1,106 towards his fees. He has a balance of $40 and he is current at this time. The case is set to expire April 13th, 2022. This is his first violation report, first MTR. We have no record of him completing any of his 36 hours community service or the DWI intervention class. He's had 6 negative drug tests, 1 positive for alcohol on the Smart Start mobile, where he's currently testing at 4 times a day, and has had 16 skips and 1 high BRAC of 0.063 at 6:56 in the morning, and he did not blow to clear until 1:33 in the afternoon. He has 1 prior arrest for an obstruction of highway, which was dismissed on deferred adjudication. And his officer is recommending that we move him to a SCRAM device and that he start his DWI intervention within 10 days.
Has Mr. Lideker already taken or in the process of taking the CATSNP outpatient drug program yet?
I have no record of that, Judge.
Mr. Butcher, is Mr. Lideker in the process of taking the CATSNP course, or I can ask him directly if you'd rather?
Yes, Judge. I don't know if the CASNIP, I know that he is already enrolled in the DWI intervention class. And that when I conferred with Ms. Gross, she doesn't have a record of that. I don't know how that's different from CASNIP.
Ms. Gross, was Mr. Lideker ordered to take the DWI intervention program originally?
Judge, I'm showing he was ordered DWI intervention because he had a prior obstruction of highway, but I am not showing that he was ordered to take CATSNP. I'm double checking your original order from the date he was placed on probation.
We'll fix all that. All right. Would everybody agree that the big issue here is that Mr. Lideker is still drinking? Although we only have 1 finite instance of that at a 0.63, but we have several skip tests. Everybody agree that that's kind of the elephant in the room? Mr. Butcher, would you agree that that's our problem?
Yes, Judge.
Okay. Is Mr. Lideker willing to go on the SCRAM device at $350 a month? Because in this hand, we have like Bear County Jail for a year, and in this hand, we have like SCRAM bracelet. What would be better for Mr.
Right. Yeah. Accordingly, I mean, we're inclined. My client works. He works at a major medical lab. As you can see, he's in the medical field. He has problems with the SCRAM device because he'll have to wear that while he's visiting with patients and clients. But for right now, if that's the alternative to jail, he's inclined to do it.
Yeah, Mr. Lideker, I don't want to set you up for failure. This thing is very expensive. It's like $350 a month. You would be on it for at least 90 days. If you do really well in those 90 days, we can talk about coming back on a Smart Start mobile device again. But that has not been your forte in being a good probation so far, as utilizing the Smart Start correctly. So that being said, is that something you'd be willing to do? Because you're going to have to pay for it. It's not, your lawyer and I are not paying for it.
Yes, Your Honor.
All right, good answer. State recommendation, please.
Your Honor, I would concur with the probation office's recommendation of adding the SCRAM device and beginning that DWI intervention class within 10 days.
Okay. Mr. Lideker, in clause 628043, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your probation or to continue on probation with all prior requirements with no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, sir?
No, sir.
All good. Altering and amending conditions, adding the SCRAM cam device within 10 days. If there's a problem with that, sometimes they get backlogged and you have to wait longer. Just stay on the Smart Start mobile till they can get you on the SCRAM cam device. As soon as the SCRAM cam device is active, you can turn in your Smart Start mobile and save yourself the $95 a month or whatever that is. Alter and amend, add Community Alliance for Traffic Safety Intensive Outpatient Program, continue DWI intervention, order weekly report in UA. Once he shows me 4 clean UAs in a row, i.e. 4 weeks of clean UAs, I'll put him back on monthly UAs, Mr. Butcher. I will not know he's done that. If he does it, you got to have him tell you, and he can tell me. And Susan, go ahead.
You said weekly report and weekly UA. Can you correct that, please?
Weekly UAs. He's on probation. I apologize. That was a pretrial order. So he'll be on weekly UAs. If he shows me 4 clean weekly UAs, we'll put him back on monthly. And substantial compliance in all other areas, which I think he's pretty much done. Ms. Gross, would that be accurate?
He also still owes us the community service, Your Honor.
All right, he can either start doing community service hours, or he can donate $10 an hour to court charities, which are primarily special operations wounded warrior organizations or family violence prevention organizations.
And you
Your
want
Honor, you waived my community service based on the fact that I'm prior
Are you a
military.
veteran, sir?
Yes, sir.
And what did you do in the military, sir?
As a combat medic.
All right, yeah, we've already probated his community service hours. there.
Okay, I'll make sure his record gets updated. And you want substantial compliance within how many days?
10 days. He just needs to be registered for any programs he's not registered for.
Judge
All right.
Christensen, I'm sorry, if my client has informed me that he wants to seek a travel authorization from January 10th to the 17th. He has a trip to Disneyland with his children that's long been planned, small children. And I can submit a travel authorization to the court, but I wanted to mention it now.
Mr. Lideker, you're not going to go out there and go goofy on me, are you?
No, sir.
Good
To
comment.
celebrate my oldest stepson leaving for the Air Force, sir.
All right, you're going to be wearing your ankle bracelet out there, and it'll be active out there, no problem. It's going to be authorized. Go ahead and give me a simple request for travel in writing, so it'll be something on the record on the computer, and that's not a problem, okay?
I'll submit that today.
Yes, sir.
Anything further from the state of the defense on Mr. Lideker?
I think further from the state.
Good luck, Mr. Lideker. Thank you, Mr. Butcher. Y'all are excused. Susan, do you have anything else you need to tell them? Go ahead.
Okay, Mr. Lideker, sometime later today, you'll be receiving an email from me. It will have your amended conditions on there. I will send your paperwork also over to your officer, and then she will send your referral to Scram. Okay, you will be signing the Scram, so you'll be able to see the information, and the address will be in the upper right-hand corner. You can call them because they probably have a waiting list. So give them a call today to find out what the status is. Let them know that the referral will be forthcoming either today or tomorrow. Make sure that you sign those documents and get them back to me immediately, okay? Because I have to file them with the court in order to get all this going.
Yes, ma'am.
Okay? If for some reason you talk to Scram and they say, we're not going to have a device for 2 weeks, make sure that you let your officer know so that she can document that so that it is not held against you and a new warrant issued for your arrest for lack of compliance. Okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right. Good luck to you, sir. Thank you, Judge.
Thank you.
You bet. Okay, Mr. Farmer, are we ready to proceed on Mr. Sanchez?
Yes, Your Honor.
Thank you. This is cause 657-492, State of Texas versus Cedric M. Sanchez. This is a motion to revoke community supervision. I have 2 documents for y'all to identify your signatures on. The first one is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Sanchez, is this your signature on this document, sir? Mr. Sanchez, are you with us?
Yes, Your Honor.
Can you turn your camera on for us so we can see you, sir?
Yes, sir. Yes, sir.
Oh, I got you. Thank you, sir. Okay, and Mr. Farmer, is this your signature as attorney for Mr. Sanchez on this document also?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification, a Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Mr. Sanchez, is this your signature on this document also, sir?
Yes, sir.
And Mr. Farmer, as attorney for Mr. Sanchez, is this also your signature on this document?
Yes, Your Honor.
Thank you. And Mr. Farmer, my understanding is this is an uncontested motion to revoke community supervision. Is that correct?
That is correct.
Mr. Sanchez, in cause 657-492 on the motion to revoke community supervision, how do you plead, sir?
I'm guilty.
Would that be true with an explanation, Mr. Farmer?
Yes, Your Honor. It'll be true with an explanation.
All right. Is that okay with you, Mr. Sanchez? Mr. Sanchez, you're going to plead true with an explanation. Is that okay with you?
Yes, sir. Sorry. I'm so
All right, thank
sorry.
you. And Ms. Gross, would you please advise the court and the parties of the status of Mr. Sanchez's probation?
Yes, Your Honor. Mr. Sanchez was placed on probation on September 23rd of this year. He had been on deferred. The deferred was revoked. Since that time, his reporting has been very poor. He failed to report last month, so that means he's only reported one time. He has paid $467 towards his fees. He has a balance of $432. He's current at this time. We have no record of any of his 36 hours of community service having been completed. He has one diluted drug test. We have no proof of enrollment or completion of the drug offender education program, the CATSNP program. And also on September 27th, 2021, the court did also make it a condition that he show substantial compliance within 10 days. And by not getting those classes done, he is in non-compliance. This is his first violation report, first MTR. His prior arrest history includes assault, bodily injury, evading arrest, and a possession of marijuana 0 to 2 ounces. His officer is recommending that he shows substantial compliance within 10 days and that we add a scram device and transfer him to Atascosa County.
Is Mr. Sanchez currently in Atascosa County?
Mr. Sanchez?
Where are you right now, Mr. Sanchez, physically?
Alacosas.
At-
Oh, I'm at work
All
in
right.
San Antonio,
It's
Texas.
San Antonio. Okay, I got you.
But where do you live, Mr. Sanchez?
Alacosas. Alacosa, sorry.
Atascosa. Okay. Defense, what you're requesting?
Your Honor, it would be to place him back on probation just with the bond increase. Mr. Sanchez, the reason he stopped reporting was, I guess, because there was an active warrant that was issued for him. He had been going for, I guess, the month or the weekly UAs, and he did not hear from probation, and he phoned in and found out that he had an MTR that was issued. He does have 3 children, with one being a newborn. And in order for him to take care of them, he wanted to have this MTR situation resolved before he went in and was picked up on the warrant. As far as the drug offender program, he had completed a course. However, I think probation said he had to have a certain number of hours that were higher than the course that he had done. And Mr. Sanchez, you had completed the course, is that correct?
Yes, sir. I had emailed it to my probation officer when I had completed it.
Okay, and I believe that was a drug offender program, right?
Yes.
Okay, and then as far as the community service hours, have you done those yet?
No, sir.
Okay, and I believe Mr. Sanchez would be willing to pay, I guess, the amount of $10 for the community service hours to get them completed. But as of right now, we'd just like to get him placed back on deferred without the scram device. I do not believe he's able to afford the scram device. And I guess the 2 violations that came up, they came up as diluted, where I do not believe he's trying to avoid the testing. He may have like an issue with his kidneys or something else going on, because he has not been tested positive for anything, Your Honor.
We're getting diluted drug tests. We've got 2 diluted UAs. Why are we getting diluted UAs, Mr. Sanchez?
I really can't tell you that answer, sir. I wake up early in the morning to go do the drug test. I rarely drink water. The first time I drank Gatorade, I didn't know it was gonna dilute my test. And the second one, I did not know
A lot of
why.
Gatorade. Okay, Susan, when is the last valid urinalysis test we have on Mr. Sanchez?
Let's double check here, Judge. The last test I have in the system is October 18th, which was diluted, and prior to that, it was October 15th, which was negative. His last positive was back when he was on deferred in August 17th. for marijuana.
Okay, is he currently supposed to be on weekly UAs? Is that correct?
Yes, sir.
Yes,
All right. So what happened last week? Was it diluted?
I do not believe he took the test last week out of fear of going in and being picked up on the warrant.
Okay, so the last UA he showed up for and actually took was diluted. Is that correct?
October 18th. That is the last one that I show is on file.
So it's December and we don't have any UAs in November, correct?
Correct.
Was he supposed to report in November for UAs?
Yes.
State recommendation on Mr. Sanchez, please.
Your Honor, the state agrees with probation's recommendation in this case.
And this is his second MTR, the first August of 2021. Does that sound right?
No, Judge, this is his first MTR on the regular case. He was on deferred and he had an MTR and you revoked him. But on the regular case, since he's been placed on regular probation in September, this is the first MTR.
However, in the entire history of Mr. Sanchez's probation, whether on deferred adjudication probation or regular probation, this is his second MTR. Would you agree?
All in total, excuse me, all in total, yes, this would be his second MTR.
Mr. Sanchez, the court in cause 65, nope, it's the wrong one. In cause 657-492, accepts your plea of true on the motion to revoke community supervision. I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bexar County Jail, assess a $2,000 fine plus court costs. No, wait, what was his fine amount on this case? That's what we have to use.
200, Judge.
$200 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on December the 10th, 2021, which is this Friday. Anything further from the state or the defense on Mr. Sanchez? I gave him 6 months credit. Otherwise, he would have been going to jail for a year for the things that he did do correctly.
Nothing from the state, Your Honor.
Anything further, Mr. Farmer?
Nothing from the defense, Your Honor. Your Honor, actually, can you please go over the conditions again? I guess the sentencing.
You mean the sentence again?
Yes.
The court accepts his plea of true with an explanation. I grant the state's motion to revoke his community supervision. Although I have the authority to sentence him to a year in the Bexar County Jail, I only sentenced him to 6 months in the Bexar County Jail. Assessing a $200 fine plus court costs. He gets credit for time served, time and money to run concurrent. And he's to report to the Bexar County Jail at 9:00 a.m. this Friday, December the 10th, 2021 to start his sentence.
Okay. Your Honor, if I may add any other thing to help him, I do not know how he's going to be able to, carry out the sentence, given the fact that he does have his, newborn infant.
He does have what? I'm sorry?
And he has a newborn. And he's also the sole provider for his family, and being, having some sort of sentence imposed against him, I do not believe his family is going to be able to get through the hardship that they're currently facing.
I have great
pretty rough
empathy for Mr. Farmer and his,
I don't know.
for Mr. Sanchez and his family. However, he might have thought about that before I gave him a first chance when I didn't revoke him on the first motion to revoke community supervision. This is the second one. And he's still not doing things right. I can't do it for him. So I apologize it's that way, but it's that way. So anything further from the state or the defense on Mr. Sanchez?
Nothing from the state.
Nothing, Your Honor.
All right. Good luck, Mr. Sanchez. Thank you, Mr. Farmer. You're all excused. Mr. Porter, we ready on 652-949 to the Texas versus Christopher Bowe?
Judge, good morning, sir. Yes, we're ready to proceed. Mr. Bowe is sitting here with me.
All good. This is cause 652-949 to the Texas versus Christopher G. Bowe. The first let me back up. This is a motion to revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which reportedly has both Mr. Bowe's and Mr. Porter's signature on it. In fact, Mr. Bowe, is this your signature on this document, sir?
Sir, yes, sir. Yes, Your Honor.
And Mr. Porter, as attorney for Mr. Bowe, is this also your signature on this document?
Yes, sir, Judge.
Pat, administratively, my copy of this document does not have a date on this document, so that needs to be dated today.
Yes, sir.
The next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, well, it's mismarked. This says it's a plea bargain case, but it's not a plea bargain case. Should be marked as a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. So Pat, that marking needs to be changed. And other than that, is this your signature on this document, Mr. Bowe?
Sir, yes, sir.
And Mr. Porter, as attorney for Mr. Bowe, is this also your signature on this document?
Yes, sir.
Thank you. And my understanding, Mr. Porter, is this is an uncontested motion to revoke community supervision. Is that correct?
Yes, sir. That is right, Judge. We are ready to proceed.
Mr. Bowe, in cause 652949 on the motion to revoke community supervision, how do you plead, sir?
Sure. With explanation, Judge.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Bowe's probation?
Yes, Your Honor. Mr. Bowe's reporting has been good. We last saw him on November the 4th of 2021. This is his fourth violation report, second MTR. He's paid $934 towards his fees. He has a balance of $420 and he is current at this time. He has completed all his required sanctions to include 24 hours community service, victim impact panel, CAT-SNP, and the DWI intervention class. He has had 3 positives for alcohol on the Smart Start mobile device historically. He's currently testing 6 times a day. He's had 1 skip and he had a high BRAC on November 25th, which ranged between 023 and 029. He did admit to the using of alcohol, which triggered the device to test positive. His prior arrest history includes possession of marijuana, 0 to 2 ounces, DWI, unlawful carrying of a weapon. His officer is recommending that the time on his current device be extended or that he repeat the CAT-SNP program.
I have the MTR that we're dealing with currently is dated December 3rd, 2021. Is there a prior MTR, did you say?
Judge, he's had 4 prior violation reports, which has resulted in 2 MTRs.
What date was the last MTR heard?
That was heard on July 20th, 2021.
And what were the allegations on that MTR?
I'm sorry, I thought I'd sent that to you.
Copy this time. Pardon me?
I thought I'd sent that to you. Let me pull it up here.
I think in all the other cases you did.
On that MTR, the violations that were alleged on that one include alcohol consumption, 0.019, and failure to do his classes, and that was it.
Did I crank up his Smart Start mobile device to 6 blows at that time?
As a result of that, you altered and amended to increase from 4 to 6 on the device and ordered that he show substantial compliance within 30 days.
Is he still blowing 6 times?
Yes.
He is. Okay, Mr. Porter, I guess the elephant in the room on this one is we can't stop him from drinking. What do you got for me?
Judge, that is correct. Mr. Bowe has been compliant with all other conditions. He hasn't had any skips. I think Ms. Gross noted that he had 1 skip, in the past 30-day period that we're looking at, Judge. The instance that we're here for, Judge, is a high BRAC. It was on 11/25. He drank alcohol, Judge. He admitted it to his probation officer. He contacted me immediately. Ms. Gross can correct me if I'm wrong.
Wait a minute. Stop right there.
Yes, sir.
Are you telling me we have a truthful probationer we're dealing with at this time?
Judge Christopher Bowe is a truthful probationer.
He's still in my heart. Go ahead.
He is a truthful probationer, sir. The record reflects that. The warrant, which we actively were looking for, Judge, went live yesterday. We immediately contacted the court because Mr. Bowe wants to come in front of you and try to write this. We're not here to give excuses, Judge. He admits he's got an issue with this. He's already on my counsel proactively re-registered to do the DWI intervention program in person again. He is re-registered for that and is supposed to begin that next week, Judge, if this court will allow. Judge, just personally, and I know this is in what you have, but Mr. Bowe he is gainfully employed at IBM. He's got a 7-month-old child. He cares for his elderly mother. And he also, Judge, has a new baby that's on the way. So he wants to try to get this right, Judge, and we would just ask that you give him an opportunity to do that.
Is Mr. Bowe willing to volunteer to go on the scram cam device at $350 a month?
If that is what this court requires, Judge, he is willing to do that. Yes, sir.
Can you move your camera so I can see Mr. Bowe and talk to him with your permission?
Yes, sir.
Mr. Bowe, I'm running out of options. The way I try to do this in sort of a staggered manner, everybody that's on a Smart Start mobile device that is charged with a DWI type offense starts at 4 blows a day. That's every 6 hours. If they offend, like you did in your case, and they're still drinking, we crank it up to 6. With the understanding if they show us a clean 30 days, we'll crank it back down to 4. I'm still getting positive UAs from you. And the only next step up, other than jail, which I assure you will ensure you won't get into any more alcohol, is a scram device, which is an ankle bracelet, which tells me if you're drinking. It doesn't stop you from drinking, but it lets us know immediately when you are. And that's the only tool I have left in my toolbox other than jail. It's very expensive. It costs $350 a month. The deal I would make you, as I make every defendant that I put on a scram device, is you're going to be on it for at least 90 days. I think you only have about 6 months left on your probation, God willing, and the creek don't rise. Susan, would that be more or less accurate? It's the next June, I think.
May 26th.
All right. So for at least 3 months, you'll be on that scram device. If there are any problems, you're either going, I doubt you'll be worried about the scram device because jail is our next option up. Are you willing to volunteer and pay that $350 a month for a scram device and not go to jail on this one?
Yes, Your Honor.
All right, good answer. State recommendation, please.
Your Honor, the state agrees with probation's recommendation in this case, as well as adding scram.
Mr. Bowe, in clause 652-949, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your community supervision. Order you continued on community supervision with all prior requirements. I'm going to give you a sanction of 30 days in jail to get your attention. Is that going to be necessary in this case, sir?
Sir, no, sir. No, Your
All
Honor.
right, I'm going to hold that 30-day sanction in abeyance and continue you on regular probation, adding the scram cam device within 10 days. Hopefully, if there's a problem, your probation officer will fix it. You stay on the Smart Start mobile device at 6 blows a day, continue blowing in that until we get you on a scram device. Then you can turn in your Smart Start mobile device, put him on weekly UAs, Susan. Once he shows me 4 clean weekly UAs in a row, we'll take him off of that, put him back on monthly. Alter and amend to add intensive outpatient with the Community Alliance for Traffic Safety and substantial compliance in all other areas within 10 days. Was he ordered to do the Community Alliance for Traffic Safety basic program? I'm assuming he was.
Yes, he's already completed CAT's NIP.
Well, it's not working. So let's do IOP and see if that's any better. And Susan, what else do we need to do? Or do you think that will take care of it?
That should cover it, Your Honor.
State, anything else you think we need to do with Mr. Bowe to make sure we don't have any more problems?
No, Your Honor.
All right. Mr. Bowe, we have an understanding. Any more problems? Your fault, my fault, nobody's fault. I only have one tool left in my toolbox, and it's spelled Jail. Mr. Porter, have a very short conversation with your client. Explain what I mean to him, because I think he's probably figured it out by now.
Judge, I will do that. The only other item I have, Judge, is because we did come in immediately on this, there is an active warrant. If we could just have that.
We're gonna recall all prior bond conditions on his MTR bond, including the warrant, and he starts over basically. And that will probably not take effect till tomorrow. So I wouldn't be speeding around town this afternoon or anything to attract attention from the local constabulary, but otherwise that'll all work out.
Thank you, Judge.
And I'd like to commend the defense for being probably the only lawyer in the free world that has ever come forward and truthfully said they have no excuse and we did this and we want to fix it. So thank you very much for that. And that's probably what saved your client. So Mr. Bowe, thank Mr. Porter because he saved your butt. All right. Good luck, Mr. Bowe, and thank you, Mr. Porter. Y'all excused.
Thank you,
Mr.
Judge.
Bowe, Mr. Bowe,
Yes, ma'am.
not you, Trey. There you go. Mr. Bowe. Later today, you're going to be receiving some documents in your email from me. You need to sign those and send them back immediately so that I can get them processed, okay? Touch base with your officer, let her know what happened this morning and that you're still on probation. And then once I get the document signed by the judge, then they'll go to your officer and she'll send it over to Scram in order for you to go over there. You will see the Scram referral this morning that has the phone number on there. Just like I told the other guy, call over there today, see what the status is and see if you can get on the list and let them know that the referral will be forthcoming. Do you have any questions?
No, Ms. Gross. Thank you.
All right. Good luck to you. Thank you, Mr. Porter.
And Mr. Bowe and Mr. Porter, just make sure that you put a tickler on your calendar in 90 days. If he's done well on Scram, we're going to put him back on Smart Start, but I will not remember to do that unless you bring it up to my attention. Okay.
We'll do it, Judge. Thank you, sir.
And also same thing with the UAs. It shows me 4 clean UAs. He's got to tell you, you got to tell me. I'll confirm it with Ms. Gross and we'll put him back on monthly.
Yes, sir. Thank you,
All right.
Judge.
Trey, one more thing. Was he signed up to do DWI intervention again at CATS?
Yes, ma'am.
All right. Have him talk to Dean and see if he can transfer the funds that he made for a deposit on intervention over to the IOP.
I will do that.
If there's a problem, call me.
We'll do that. Thank you, guys.
Thanks, guys.
Take care.
Mr. Vogt, are you ready to go forward on cause 660-911 State of Texas versus Matica Jackson?
Yes, Judge, we're ready.
Thank you.
Judge, real quick before you get started, I'm being called down to that trial in County Court 5 to go finish up real quick. Is it okay if I be excused? I've already talked to Eddie and he'll be
Sure.
ready to.
As long as Eddie's ready to take over, we're good.
Okay. Y'all have a good
Eddie,
day.
take over. All right. Once again, this is cause 660-911 State of Texas versus Matica L. Jackson, represented by Mr. David Vogt. This is a motion to revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Ms. Jackson and Mr. Vogt's signature on it. In fact, Ms. Jackson, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Mr. Vogt, as attorney for Ms. Jackson, is this your signature on this document also?
Yes, Judge.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. And in fact, Ms. Jackson, is this your signature on this document also, ma'am?
Yes, Your Honor.
And Mr. Vogt, as attorney for Ms. Jackson, is this also your signature on this document?
Yes, Judge.
And Pat, administratively, my copy of this document does not have a date on it. If you'd please ensure that administratively it's dated today.
Yes, sir.
Okay. And Mr. Vogt, my understanding is this is an uncontested motion to revoke community supervision. Is that correct?
That's correct, Judge. We are pleading true with an explanation.
Fair enough. Ms. Jackson, in cause number 660-911 on the motion to revoke community supervision, how do you plead, ma'am?
True with an explanation.
Thank you, ma'am. Ms. Gross, would you please advise the court and the parties of the status of Ms. Jackson's probation?
Yes, Your Honor. Her reporting has been good. We last saw her on November 3rd, 2021. She's paid $147 towards her fee. She has a balance of $1,152, and she is delinquent $123. We have no record of any of her 24 hours community service having been completed. She has completed victim impact panel. We have no record of completion of DWI education or the CAT-SNP program. She's currently testing on Smart Start Mobile at 4 times per day, and she has had 35 skip tests and no high bracs. Those tests that were skipped were between September 29th and November 29th. This is her first violation report, first MTR. Her officer is recommending that she be continued on Smart Start at 4 times per day.
If she won't blow in the machine, how can we effectively monitor what she's doing?
Judge, I have a recommendation.
All right, sure, go ahead.
So Judge, she is employed by Chase Bank and her work shift is 12 p.m. to 9 p.m. And so by the time she gets off work, she eats dinner, she cleans the house, she does whatever personal errand she has. She goes to bed between 1 and 2 a.m. and her first blow window is between 5 a.m. and 7 a.m. And so speaking with Officer Gross, the majority of the skip tests are in that window. Sometimes the machine will actually alert her and she'll wake up and do it. And then sometimes, unfortunately, she sleeps through it. But she has another testing window between 12 and 2 p.m. So when she gets to work, she blows. And as Honorable Ms. Gross says, there weren't any high bracks. And it's not my belief that she's drinking alcohol when she gets off work and quote unquote sobers up before her work shift. What I recommend doing is adjusting the blow windows so that her first blow can be, let's say, between 9 and 11 a.m. That would be consistent with her work schedule and her sleeping schedule. As Officer Gross stated, she is reporting. As far as the monies go, she was going to make a payment at her visit with probation this week, but she had to pay us to help us get on the docket quickly. And I hope that's not held against her. But we found out about the warrant, I believe, on Monday, and we got into court as quickly as possible in order to address this and make sure that we were, on top of things. As far as she has completed the victim impact panel, and the dialogue with her and her officer was to sort of get one thing done. Okay, let's schedule out the next thing. And so as far as the DWI education and CATS, her plan was to get registered for those and get the information from her officer this Friday with her at her next report date. As far as community service, she has contacted a couple of the organizations and gotten a quote for what it would cost to make a charitable donation, and was going to get permission from her officer to donate those because of her work schedule really taking up the majority of her time. And so for those reasons, Judge, we would ask that you follow the recommendations of probation. She has no objection to whatever the court would decide in terms of the Smart Start Mobile. We would just ask that maybe the court consider allowing her and her officer to set the times, just so that we won't be back, because she'll be in 100% compliance. She is taking this seriously, though. She did hire me right away, and she used pretty much every dollar she had to get me on the case to approach you this morning and get this done.
Well, that's the first really good judgment she's shown on my probation. I don't know, but here's my problem. A, I'm not worried about her reporting. She's reporting well. B, I'm not worried about her money. She can catch up for $123. C, I'm not worried about her community service. She's got plenty of time to do that. I'm not worried about DWI Ed or the CatchNet program. She will do that in time. I'm worried about the fact we can't monitor her effectively for drinking, which is what she's on probation for. 35 skips is about 33 skips too many. So we can't use the Smart Start mobile device because she doesn't blow into it timely. We're not going to modify her hours around her so the tail wags the dog. So that scram is the only option I've got left. So in this hand, I've got jail. And in this hand, I've got a scram cam at $350 a month. Can Miss Jackson afford a scram cam as opposed to going to jail for about 6 months?
Well, Judge, obviously, we wouldn't want her to go to jail for 6 months.
No, we wouldn't, but we wouldn't want her to continue missing my blows on my Smart Start mobile either, would we?
Correct. I guess if of the lesser of the two options.
You all want to go in a break room and chat about that? I don't want to set her up for failure, meaning if she can't afford this thing, we're wasting our time. We're going to be right back here within 30 days.
Gotcha. Okay, Judge. Let me confer with her briefly. We'll be right back.
Sure, absolutely.
Going to room 6. Your Honor, Mr. Frolick's person has signed. That's Ms. De La Garza. We just need for you to sign it and get back.
Okay, 5-minute break. We'll do paperwork. Do I have paperwork both on
No, Mr.
Taylor Cruz
Mooney,
and Mr. Mooney, or just Ms. Taylor Cruz?
just Ms. De La Cruz, Your Honor. Mr. Bravanek has not come in yet.
Okay, all good. Stand by.
Okay.
Pat, before you get up, too late. Never mind.
Uh,
I was
I'm,
gonna see if I can get a breakout room with Eddie and Susan to figure out what we're doing.
okay, I can still do that. I'm here, not a problem.
Sorry, I meant to do it before you get up.
It's okay. All right, I'm gonna put y'all at 7. I just think that'd probably be easier. All right, let me find you. 7 and Susan. 7. There you go. Okay. Susan, 7. Okay. Disclosure.
We're back, Judge, when you're ready.
Mr. Vogt, he's trying to get some paperwork that printed, and that's why he hasn't come back.
We have been together.
Now, can you hear me, Mr. Vogt?
Yes, Judge, I can.
Okay. You and Ms. Jackson were able to go back in a chat room and discuss the possibility of a scram cam device and the expense involved. And what did y'all decide?
Your Honor, do I need the prosecutor here and Susan?
Yes. Where did our prosecutor and Susan?
They went into a breakout room.
They're back.
Eddie's back. Susan's still in the Bermuda Triangle of County Court 6 Zoom. Nope, Susan's back.
That's my fault, Judge. I wouldn't stop talking.
Not a problem.
And Judge, I would like to bring up with you that when you have a chance, the state does have a motion to make on Ms. Dela Cruz.
All right, well, we'll hang on just a second until we finish on Ms. Jackson's case.
Oh, yes, sir.
So we're back on the record on Ms. Jackson's case, called 660-911. And defense counsel, Mr. Vogt and Ms. Jackson have been in a chat room discussing the possibility of utilizing a scram cam device in lieu of the Smart Start Mobile. And Mr. Vogt, what did y'all decide?
Judge, can you hear me?
Can you hear me? I can hear you.
Yeah, okay. Yeah, sorry, my audio dropped. I did speak with Ms. Jackson. We would be in agreement with the imposition of scram in order to resolve this favorably. I had one idea if the court would just entertain that way we covered all the possible angles.
Sure.
The court could impose scram as a condition, but hold it in abeyance. And during that time period, put her on 0 tolerance with 6 blows a day. That way, if there was any violation, even one, then the court would not have to have a hearing and could impose scram at that time. I thought that might be a bridge from, like the court described, the staggering of conditions. She hasn't had the opportunity to prove herself at 6 blows a day after appearing in court with her counsel, with the warrant being active. That would satisfy both the court's condition to impose scram, but the defendant's wishes to have scram held in abeyance instead of ordered. That was my idea. She's on board with whatever the court orders as long as she doesn't have to go to jail.
But for the fact I've got 35 skips as a matter of historical record at 4 blows a day, that ship has sailed. But thank you for that possible option, which is not going to work in this case. So if y'all are agreeable to scram cam, I'm ready to rule.
We're ready.
State, did I get your recommendation on Ms. Jackson yet?
No, Your Honor, but that is our recommendation that she be placed on scram.
And Mr. Vogt, scram cam is going to be required for 90 days. If she does well in 90 days, I'll put her back on a Smart Start Mobile. I won't know that she's done well. She'll have to tell you, you'll have to tell me, and I'll have to confirm it with probation. She just went on October 14th, so she's got until next October plus or minus on
Correct.
probation. Yeah.
And also, Judge, will the court allow the Smart Start Mobile to be removed at the time?
Absolutely.
Okay.
You bet.
And then obviously with the completion of the MTR, we'd ask that the warrant be recalled as well.
Of course. As soon as the scram cam is active, she's eligible to turn in the Smart Start Mobile device.
Fair enough.
Okay, Ms. Jackson, in clause 660-911, the court accepts your plea of truth and explanation. I deny the state's motion to revoke your probation, or you continued on probation with all prior requirements and no sanction at this time. Altering and amending conditions, ordering the scram cam device within 10 days if there's a problem. Sometimes they get backlogged on those devices. Your probation officer will handle it, just let her know what's going on. Susan, anything we need to add on this other than substantial compliance? She's behind on monies barely. She hasn't done community service hours. She still needs to do DWI education and enroll for CATSNP. I want her enrolled in all those courses within 10 days and start making a plan for community service. You can either do it or donate $10 an hour to a court charity, which are primarily special operations, wounded warrior organizations or family violence prevention organizations. And she will get credited at $10 an hour. Susan, what did I miss?
Nope, I think we're good to go. I just need to give her some instructions when you're done.
State, what did I miss?
Nothing, Your Honor.
Defense, what did I miss?
Nothing further, Judge, and I just asked Ms. Jackson to call me when she's done talking to probation.
Okay, you have any questions, Ms. Jackson?
No, Your Honor.
All right, thank you for your help.
Thank
Susan, go ahead.
All right, Ms. Jackson, you'll be receiving documents via your email today. You need to electronically sign those and send them right back to me, okay?
Yes, ma'am.
Just like I told the other two guys, you'll see the address and phone number of where to get Scram. And you can call them and check the status, see if you can get on the list and let them know that your referral will be forthcoming and probably the next day.
Okay.
Okay, do you have any questions?
No, ma'am.
Okay, once you provide proof that you're strapped on Scram to your officer, then she'll send an order to me. I'll get it to the judge. He'll sign it, and then it'll be sent over to Smart Start. Then you'll be able to go turn in the device. So, but once you're on Scram, you don't have to blow anymore, okay?
Okay.
All right, good luck to you.
Thank you.
May I be excused, Judge?
You bet. Thanks for your help.
Good one.
Okay, Mr. Froelich, are you ready to proceed on Ms. De La Cruz? Oh, wait. Mr. Villarreal, you had a issue with regard to Ms. De La Cruz probation.
Yes, Your Honor, the state does move to withdraw the motion to revoke at this time.
Let's have a brief discussion about that. We haven't seen her since 2017 and the state wants to withdraw. Explain that to me.
Yes, Your Honor, Ms. De La Cruz was on a felony. She had a felony and now she's been placed on deferred adjudication for 5 years on that felony, and she has an underlying 20-year sentence on that. And so after speaking with felony prosecutors and my partner, we did determine that the best thing to do would probably be to withdraw this motion.
Ms. Gross, I got a question. Did this case run concurrent with the felony case?
Judge, the felony case is new. It occurred after the probation expired.
Is that one of the allegations on the MTR?
No, because it occurred after the case expired. We can't amend an expired case.
So basically, Ms. De La Cruz is still on probation in the other case. Is that what's going on?
No,
Yes.
she just got put on yesterday.
Ah,
That's my understanding anyway.
That is what happened. Yes, she was placed on deferred yesterday for a second-degree case.
and here's the big question of the day. Does she have a driver's license?
Judge, she is required to get one under that was not the terms of the plea bargain, but I added it at the last minute. Stephanie Boyd is now ordered her to get her driver's license.
What does she need to do to get her driver's license?
If I wish I had asked her that question prior to this
Well,
hearing.
normally
Judge.
there's an accident and they owe money on it, or they've had too many traffic tickets, or who knows what.
How about this, Judge? If you agree to let her terminate, I promise you, I personally will help her get her driver's license. Free of
Can't beat
charge.
that. State's motion to dismiss the first amended motion to revoke community supervision on Ms. De La Cruz and clause 347834 is granted. Just give me something in writing at your ability.
Judge, how do you want to terminate the case? Because it's expired. If you withdraw it, the case goes away. Are you terminating satisfactory or unsatisfactory?
Let's term unsat. Would that be all right with the defense under the circumstances?
Under the circumstances, Judge, I have absolutely no objection. You can call it whatever you want. Satisfactory, unsatisfactory. I don't give a rat's patoot
Term
how you
unsat.
do it. Yes, Your Honor.
Ms. De La Cruz, just so you know what's going on, Mr. Froelich just saved you about 6 months to a year in jail. I hadn't decided how long to put you there. So anyway, well done. Thank
I
you.
thought it was a class B, so I'm thinking it might be limited. But yes, the fact that you're
Yeah,
deciding.
well, that's enhanced. Isn't that a class A?
Beside the fact that if we're talking about at least 6 months in jail, yeah, let's just call it that.
Her underlying is 6 months. Andrew, the judge will sign the paperwork in the morning. So it'll all be put through tomorrow morning.
Tomorrow morning?
I'm in hearings and I got to get all this other paperwork done and sent out to the defendants. I'll try and get to it today, but I can't make any guarantees.
Okay. As soon as we can. Thank you. It's the only
Good luck,
thing
Ms. De La Cruz. Great job, Mr. Froelich.
Thank you, Your Honor. And Mark, don't forget to report to probation the moment you are released.
Okay, what else we got today?
We'll work on
Honor,
the Zoom.
at this
Thank you, Your Honor.
point, Mr. Bravenek has not contacted me to give him my cell number so he could let me know. what is
Let's
going
initiate
on.
Mr. Gordon's hearing. Have we got the DA on Mr. Gordon's case?
And not yet, Your Honor. And Mr. Gordon just sent you an updated version
Oh,
of
good.
disclosure, and I sent it to you and Miss Bound.
And Mr. Mooney apparently is in jail. Here's what we're gonna do. We're gonna stand by and see if Mr. Bravanek can show up before we finish this other hearing or briefly after. And if that doesn't work, we're gonna reset this to tomorrow and we'll just tag it on with our pleas in the afternoon. Will that work? Pat?
Ms. Bowen is coming in, Your Honor. And like I said, I just sent you an updated non-disclosure he sent me.
Okay, let me take a 5-minute break and get my documents in front of me. I'll be right back.
Ms. Bowen, did you get the email that I sent you with the updated non-disclosure that Mr. Gordon provided just a while ago?
Yes, ma'am.
Okay, great. Judge is just getting his copy right now, so that's where he is. Mr. Brodnick, I'm going to put you in a breakout room with your defendant so you may talk to him as well as have him sign the paperwork. We're going to be doing a non-disclosure hearing real quick, so you have time to talk to him.
Okay, Pat, I did sign the documents. I don't know if he's going to do it, but I'll go over it with him, okay?
Okay, I appreciate you doing that. If you could go in one
Thank you.
and go into one, Mr. Mooney, you should be able to join. See it, join right there and hit it. Mr. Barry? Mr. Berry, do you have video? Because we need to see you when we have the hearing. So you need to put your video on just before we start the hearing.
Can you hear her, Jason?
It shows he has video and it shows audio, but it looks like he's having issues. He may need to sign in and sign out again. Or sign out. Sorry.
Let me try to mute myself and call him.
Okay, I appreciate it.
Hope he's not using the phone to sign in though. I guess we'll find out.
Your Honor, Mr. Berry's having a little problem with video and with audio, so Mr. Gordon was trying to get a hold of him.
I did.
We're not getting audio or video on Mr. Berry at this time?
No.
Okay. And he's not answering his cell phone either?
No, he did, Your Honor. He said he's working on the settings. According to him, it says he's live, and he tested his sound and got the little beeps, but he says
sometimes they just have to sign out and sign back in, and that clears it up.
Let me tell him to do that specifically if you don't mind. I'm gonna call him right back and mute myself again.
And Judge, Mr. Brovinick is in a breakout room with his client.
Oh, good. Miss Bowen, long time no see.
Yes, sir.
They stick you in your little foxhole up there and no one ever gets to see you.
That's right. Although I certainly been seeing the veteran expunctions. Y'all are doing a good job down there.
Thank you. Was it Alexis that was our ADA that handled this case the first time around, Pat?
I thought it was, but I'm not sure, Your Honor, whether it was her or Nick.
Whoever it was did a really excellent job laying it out, and they had all kinds of documents.
No, that was.
They
I
talked to
think,
Ms.
the other
Bowen
one.
before they did their presentation.
Okay. Mr. Brovinick, was he able to sign the paperwork?
So I didn't have him sign the paperwork because he's got some felonies pending. And I know Judge Christian does things a little different than other people, and I don't know how he does them. And whatever way he does it, I want to respect. But I don't think I should have him plead true on him because probably they're going to end up getting rid of it. I signed the paperwork because I wanted to make things easy in case we add a plea. So you tell me how he does it. Should I set it for a contested? Do I talk with the state? Is he going to reset it if he has a felony pending? You tell me what he does.
How about I tell you what I do? Will that work?
Excellent. Even better.
Well, an MTR and a pending case in any other category are apples and oranges. So regardless what the felony stuff's going on, has nothing to do with us. However, the
Okay.
DA can do whatever they want to do. So we've got Mr. Villarreal, I think, still with us, do we not?
Yes, Your Honor, he's in a breakout room.
Okay. You're welcome to chat with Mr. Villarreal. There he is, he's back. And explain the circumstances. My position is we go forward on the MTRs. He can plead not true. He can request a contested hearing. The difference between a contested hearing and an uncontested hearing basically is if we can find his original probation officer, and I don't know, was this a gentleman that's been missing for a while or not?
That I don't know, Your Honor.
All right. Otherwise, Susan Gross is our assigned court supervisor for CSCD, and she just testifies about it. So there's not a real big difference between whether it's contested or uncontested. If we can get the original probation officer, we're happy to do so. And if we can't, then Susan testifies. But at this point in time, Mr. Villarreal, would you go into a breakout room with Mr. Bravanek to discuss some situations involving Mr. Mooney's cases?
Judge, I have one request. I'm about to lose power on this device. I'm going to log in on my other device because it has plenty of power.
Sure.
I'm sorry. I just don't want you to send me the breakout room. Give me a couple minutes and I'll be right back.
Not a problem at all.
Thank you.
Mr. Gordon, what did you find out?
I'm in a hearing.
So he signed back in again. Jason, can you speak up?
Yes, sir. Can you hear me now?
Sure.
Okay.
Does your camera work, Mr. Berry?
It does. I had to download the app. I went straight from the link. I just had to go ahead and re-download the app.
Well,
I don't know that he has video though.
As long as Mr. Gordon identifies his voice and says, yes, that's Mr. Berry, that's okay with me if it's okay with the state.
It says
It is okay, Your Honor.
All right.
There's
let's
no
go on the
video.
record.
It says stop video on here.
I know.
Well, all right, Jason, we'll proceed. I recognize your voice, so we'll
All
proceed.
right, we're all good. This is cause number 804299. This is a petition for order of non-disclosure under section 411.0725. Does that sound right, Mr. Gordon?
That's correct, Your Honor.
And it's been several months, I think, since we actually had a hearing on this originally. And I believe Mr. Berry was pro se originally, and then he retained Mr. Gordon. Does that sound accurate?
That's correct, Your Honor.
And we're all happy about that. So at this point in time, Mr. Gordon, since I don't have a finite recollection of exactly what we've done so far, or what the big issue in this case is, Ms. Benavides and I have 1,000 defendants on pretrial and 1,000 defendants on probation, and every darn one of them has a lawyer. So if you do the math, we get a little busy, and this is sort of back burner. So, Mr. Gordon,
Your Honor, may I?
Yeah.
May I inform you? If I remember correctly, we had that motion before us. Mr. Berry came in, and when he came in, he informed us at that time that he had hired Mr. Gordon, so everything stopped.
Okay, thank you. All right, go ahead, take it from there, Mr. Gordon.
Yeah, sure. So Mr. Berry was granted deferred adjudication on an assault case several years ago, back on December 17th of 2001. And he did complete his terms of probation successfully. And then an order was issued terminating him from community supervision on the case on December 30th of 2002. And so he would normally be entitled to an order of non-disclosure. The dispute that we have is there's an exception, as you know, for non-disclosure cases for cases involving family violence. Our position is that the order, the deferred adjudication order originally prepared, does not actually mention family violence on it. And our position is that actually needs to be in the order if that's going to be relied on to prevent him from getting a non-disclosure later on. And I do would cite to the court section of the Code of Criminal Procedure, section 42.013, which specifies what is necessary for a finding of family violence. And it basically says that in the trial of any offense under Title V Penal Code, if the court determines that the offense involved family violence, as defined by section 71.004 in the Family Code, and this is the critical part, it says the court shall make an affirmative finding of that fact and enter the affirmative finding in the judgment of the case. So our position is if you want to actually say that this case is officially a family violence case, and not just that there might have been some allegations of family violence in the police report, that there needs to be an affirmative finding in the judgment of the case. And again, that's Texas Code of Criminal Procedure, Article 42.013. And the original deferred adjudication order does not specify family violence in there. And so our position is that even though there might be facts in there that arguably allege family violence, which my client would still dispute, by the way, he would still dispute there was a dating relationship if we get that far. But our position is we don't really need to get that far, because if you want to deny him an order of non-disclosure based upon claiming this is a family violence case, the original judgment needs to specify family violence in it.
All right, let me stop you there, Mr. Gordon. And then I'm gonna ask Ms. Bowen to jump in here in a minute, but let me clarify for my understanding. The original criminal case was an ABI, or what was assault causing bodily injury. And was it designated as, nowadays we would have an F for family or FV for family violence? Was the original case filed back in 2002, I guess, plus or minus? Was that designated as a family violence assault?
2001, Your Honor. Well, I don't see any evidence that was officially designated as a family violence case. And I would say if it was, it would need to be in the judgment. Even if there's other paperwork that might mention family violence in a passing way, our argument is that would not control.
Okay.
But I'm not aware of any paperwork that officially says that. If I'm wrong, then certainly stand corrected.
The alleged victim in the original criminal assault case, did that person have a relationship with Mr. Berry in some capacity?
There was a relationship. I believe the original police report, she mentions that she was a quote unquote ex-girlfriend.
Okay, so the dating relation, they were not married at any time. Is that your understanding?
They were definitely not married.
Did they have a child together?
They did not have a child together.
Okay.
Were
they living together at the time of this alleged assault?
According to Mr. Berry, they were not living together. I think at most that they had a couple of encounters, and that gets into the idea of how far this relationship, excuse me, Your Honor.
I assume at some point, Mr. Berry entered a plea on that case, and do you know if the plea was no contest or guilty or whatever it was?
He did enter into a plea bargain, Your Honor. Let's see. It looks like he entered a plea of guilty according to the deferred adjudication order.
Okay. And he received probably what, a year or two of deferred adjudication on this case?
He received 1 year deferred adjudication. That's correct.
Was he ordered to go to the BIPP program or any family violence prevention type program as a result of his probation requirements?
I'm not 100% sure on that, Your Honor. I actually don't have all the probation terms in front of me, but I do know that he completed all the terms satisfactorily and was terminated on December 30th, 2002.
And this says criminal case number CR 804299. We don't use CR that I'm aware of. This was a misdemeanor case. So the cause number was 804299. Does that sound right?
That's correct, Your Honor. He put the CR on his pro se paperwork initially, I think.
Representing the Bexar County Criminal District Attorney's Office, Ms. Susan Bowen. Ms. Bowen, can you shed any light on what's going on this case?
Actually, Your Honor, we were not able to get a copy of the criminal case. We were told that it's been destroyed. What I do have is Mr. Berry's statements to my paralegal, who stated that she was an
I'm going to object to any of those statements being entered into the record, Your Honor.
Okay.
We haven't reviewed them anyway.
Everybody stop talking. For purposes of this hearing, I'm going to allow it. Objections noted for the record and for appellate purposes. Go ahead, Ms. Bowen.
And in addition, Your Honor, there was a probable cause affidavit submitted in regard to a protection order, which claims that.
Object to that, Your Honor, just officially.
Well, Your Honor, I'm not able to get a copy of the criminal case, so I have to
rule on the objection. Hang on just a second. State your objection again, please, Mr. Gordon.
Hearsay.
Okay, once again, I'm going to overrule it for purposes of this hearing. We're not in front of a jury, and your objection is noted for the record and for appellate purposes. Go ahead, Ms. Bowen.
So it's the probable cause assigned by an assistant criminal district attorney of Bexar County, and it states that it was a dating relationship. And that is why the state is objecting to this.
Okay.
We do not believe that there needs to be a finding of family violence officially in the order. If you look at section 411.074 of the Texas Government Code, it states that you can't get a non-disclosure if first, for any offense involving family violence as defined by section 71.004, or if the court makes an affirmative finding that the offense for which the order of non-disclosure is requested involves family violence. There is an or there, which would indicate it's one or the other. The state believes that the facts of this case indicate that there was a dating relationship between Mr. Berry and the complainant in this case. And therefore, that is why the state is objecting to the non-disclosure.
Okay, let me tell you what our standard operating procedure with regard to an affirmative finding of family violence is currently. I have no idea what it was back in 2002, but if someone was put on deferred adjudication probation for assault, bodily injury, F family or whatever, any kind of family violence case, if they, and initially there was not an affirmative finding of family violence made by the trial judge. If they successfully completed deferred adjudication probation, there was never an affirmative finding of family violence. That varies from court to court, is my understanding. Some judges and some DAs require an affirmative finding of family violence even to get on deferred adjudication probation. In our court, we've never required it if it's a deferred situation. If they violate and they get actually convicted of the offense, then there's an automatic finding of affirmative finding of family violence. So that's my understanding. I don't know what went on back then. So at this point in time, did everybody agree there's no affirmative finding of family violence on this case?
As far as I know, Your Honor.
Okay.
Yes, Your Honor.
And the state's position is that even though there was no affirmative finding of family violence, it initiated as a family violence assault, and therefore
Yes.
it comes under the code restriction for a granted motion for non-disclosure. Is that your position, Ms. Bowen?
Yes.
Okay, Mr. Gordon, go ahead.
Well, we disagree with that position, just to keep it short.
Okay, Mr. Gordon, if you were to agree that this initiated as a family violence assault, would you agree with Ms. Bowen, or would you still disagree with that's what the law says?
I would still disagree, Your Honor. I would still disagree that there's enough evidence to support that. And if you're on the fence about it, I'd give Mr. Berry the chance to maybe answer some questions about whether it was really a dating relationship after all. But again, I don't think we need to go that far, but.
Okay, do I have your permission to ask Mr. Berry some questions relevant to that line of questioning?
Jason?
Yes, sir. That's fine.
I just want to confirm one more time that you're okay with that. I mean,
Yes, sir.
Obviously.
If you want to go in a breakout room, Mr. Gordon, and chat about that before he makes his decision, you're welcome to do that.
I have before. Jason, again, you're okay with that?
Yes, sir, I am. I don't recall talking to Pat or anyone about anything, but yes, sir, I'll talk to the judge.
Okay, Mr. Berry, at this time, I can't see you, but I'm going to ask you to raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right. From your recollection, this was a long time ago, 2001, 2002. What were the actual original charges that were placed on you in this criminal assault case?
Okay, Your Honor, it was 21 years ago. Looking at the report now, it was assault. I was never arrested. She left the apartment in Helotes that she came over to after drinking and came over to my roommate and I's apartment unwarranted, like not called or anything.
And let me stop you there, sir. I apologize. What is the lady's name that was allegedly the victim of this assault?
Her first name's Aubrey.
And what's her last name?
Arredondo.
And I'm assuming you've had no contact with her since 2001, 2002?
Yeah. Actually, I saw her several years ago via Facebook,
Okay.
probably about 4 years ago.
Do y'all have any children together?
Not at all. No, sir.
Were you ever formally married?
No, sir.
Did you ever live together?
No, sir.
Would you describe your relationship with her back in 2001, 2002 as a dating relationship?
No, sir, not at all.
How would you describe it for us?
Well, we never went on dates. She came over once or twice, and I don't like to say this, but we had sexual encounter.
Okay. And approximately what length of time were you meeting this lady in any capacity?
The length of time, like, explain. I'm sorry. Like, how many times?
Meaning, did this go on for 6 months? Did this go on for a year? Was this just 1 month period of time? How long did you and she have this understanding and interaction?
I knew her for a good year, but she had a fiance at St. Mary's, so she would just come over frequently, so 2-3 times throughout the span of a year.
And do you recall what the specific allegations were on what the state said you did to hurt her or assault her?
I do. I do.
What were those?
She threw 9 cologne bottles in my room, and I reacted by throwing an iron across the room, and it hit her.
Like you'd iron your shirt with an iron
Yes,
like
sir.
that?
Yes, sir.
And do you know if she had to go to EMS or had to go to the hospital or have any medical damages?
Yes, sir. I know she did.
She did?
She did. She
Did you
left
pay-
on her.
As a requirement of your deferred adjudication probation, did you have to pay her any restitution or pay for her medical bills or anything like that?
I don't recall on it. It says, I think, I'm not sure. I am not sure.
And I have one more question, Mr. Berry. What are you doing that an order of non-disclosure is going to help you? Is this like a job thing we're dealing with?
Yes, sir. It is a job, and it's stipping 2 other non-disclosures. This one's stipping 2 other ones that I'm trying to get non-disclosures on that happened in the same year. So
are those in Bear County also?
They are.
And is Mr. Gordon representing you on those also?
He is.
Okay, good. But those are not in our court, correct, Mr. Gordon?
Correct. Correct.
Correct.
That's all the questions I have. Mr. Gordon, do you have any questions for Mr. Berry?
No, Your Honor.
Ms. Bowen, do you have any questions for Mr. Berry?
Mr. Berry, did you get a protective order against you filed by Miss Arredondo?
Ms. Bowen, it was 21 years ago. I don't recall that like being given to me. I know that that's what happens now. I was 21. I didn't know anything about that kind of stuff. I moved to Florida. Mr. Augustine was my lawyer. So I was able to go work in Orlando and then check in. Yes, ma'am. So I know that I was away from it.
Did Miss Arredondo think that y'all were dating?
She had a crush on me in high school. She's a couple years younger and she's on dance team. So she had a crush on me from high school. So I don't know what she thought.
So you actually knew her from high school, not
No, I
just
didn't know her.
1 year.
She had a crush on me. I dated a girl on dance team, and she had a crush on me. You know how that goes in high school.
So
I didn't know
probable
who she was.
cause, yes, sir. The probable cause statement for the protective order states that you punched her in the face. Is that true?
No, ma'am. In fact, I'll elaborate. I will talk. She has a J that she actually laughed about from the iron, and he laughed about it. A little J from the tip of the thing.
So you saw her after you hit her with the
Ma'am, I said she laughed about it. That can be via phone call. I said I talked to Facebook 4 years ago.
So she has a scar?
A little scar with a J. Yes, ma'am.
No further questions, Your Honor.
Okay.
What law gives us a definition of what a family violence misdemeanor assault consists of? Is there an actual definition, I would have to assume, in statute somewhere?
Well, Judge, I'll refer you to section 42.013 of the Code of Criminal Procedure.
Okay.
Yes, Your Honor.
Do you have that with you?
I have a copy right in front of me, Your Honor.
Can you read it to us?
Yes, I'll read it. It's specifically the heading, by the way, I believe it's family. I'm sorry, just a moment.
Sure.
Make sure I get that heading exactly accurate before I read it. Okay, the heading is actually called finding of family violence. Literally, that's the heading. It says in a trial of an offense under Title V Penal Code, if the court determines that the offense involved family violence as defined by the Family Code, the court shall make an affirmative finding of that fact and enter the affirmative finding in the judgment of the case. So to me, by default, if it's not entered, that means the court has not made a finding and that the case did not, quote unquote, involve family violence. That's 42.013.
All right. And do we have to go to the Family Code to find the specific definition of generally of family violence?
You can find the dating relationship definition in the Family Code, and that is in section 71.004. That's a little bit longer, but I'll be glad to read that to you if you like as well.
Go read that in the record for us, please.
Yes, Your Honor. So it states, this is, again, Texas Family Code, section 71.0021. describes, defines the term dating violence. Excuse me, Your Honor, I'm getting over a little bit of a cold here. It says dating violence means an act other, I'm sorry, let me skip to dating relationship. I think that's what you wanted. That's in section B. And it says, for purposes of this title, dating relationship means a relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature. The existence of such relationship shall be determined based on the consideration of three factors. The first factor is the length of the relationship. The second factor is the nature of the relationship. The third factor is the frequency and type of interaction between the parties involved in the relationship. So that gives you some guidelines to follow, Your Honor.
All right. Now, if you apply that definition to the relationship between Mr. Berry and the alleged victim,
I think that he's pled guilty, Your Honor, so I think she is the victim.
Yeah, I was going to say, Mr. Gordon, do you not feel like that definition covers clearly the relationship that Mr. Berry had with this lady?
I would argue no, Your Honor. I mean, can I say that it vaguely is in the category? Yes, but not every time that you engage in sexual contact with somebody does it fall into this definition. And so at some point it does become a judgment call, and that's up to you to decide. But our argument is that a couple of sexual encounters in and of themselves does not necessarily establish a dating relationship. It does talk about a continuing relationship in here. And so according to what I understand from Mr. Berry, this was basically a couple of hookups. Did he know the woman longer? Yes, but not in the context of any romantic relationship. They just happened to go to school together. So he definitely knew her for years. But in terms of any quote unquote romantic relationship or dating relationship, his argument is basically this was at most a couple of hookups. And so I think that's one issue again, Your Honor, but even setting that aside, I'll just again urge you to consider that there is no finding. And if you look at that other statute, it does imply, in fact, it specifically requires a finding be there if this case is going to be considered a family violence case. And without that finding, that alone should be enough to give him the benefit of the doubt and allow him to get this.
Okay.
May I say something, please? I didn't know her in high school.
Sir.
I didn't know her in high school. She knew me. Thank you, Mr. Gordon. Excuse me. I graduated in 98. She graduated in 99. And when I went to Alamo Community College, I met her in 99, and this took place in late 2000. So 1 year. And like I said, she was there. I don't know the guy's name, Mike. His name was Mike, and he was at St. Mary's. So that was her relationship. She would come the 3 times she came over. That I don't consider that a relationship. The person I married, that's who I was dating. And I married her for 18 years. I was married to her. We have a 16-year-old daughter.
Okay.
That I take care of.
Anybody have any questions for Mr. Berry based on his last representation and comment?
No, sir.
No, Your Honor.
In my opinion, the relationship between Mr. Berry and this lady clearly falls in the definition that y'all read to me from the family code. So there's no doubt in my mind that by law, his relationship would fall into that category. That's number one. Number two, we all agree there's no affirmative finding of family violence. But just because there's no affirmative finding of family violence doesn't mean that this case wasn't a family violence initially filed case. It would seem that whoever the attorney was that represented him way back then had an opportunity to object to the characterization of this case as a family violence case, and then maybe that wasn't done from the results that we're seeing. How do you respond to that, Mr. Gordon?
Well, I respond that makes every one of these cases presumably family violence just based on whatever the police report says. I mean, if that's what the standard's going to be, that seems to completely nullify the whole point of section 42.013, which says that if it's a family violence case, the court shall make an affirmative finding on the record. It just nullifies it, makes it pointless, apparently. That's my concern.
Ms. Bowen, respond?
Well, Your Honor, we're only talking about non-disclosures. We're not talking about the entire criminal justice system. If you look at 411.074, B1D, you have the provision that you are not entitled to a non-disclosure for any offense involving family violence. And then there is an or, the court makes an affirmative finding that the offense for which the order of non-disclosure is requested involves family violence. I think that this does give the court the opportunity to consider, even though the pleadings just say assault, but the facts indicate family violence, that the non-disclosure can be denied pursuant to 411-074.
Mr. Gordon, response to that?
Just one more time, Your Honor. I don't mean to beat a dead horse, but that statute that I quoted, and she's correct on that statute, absolutely. It does state whether the case also involves family violence. But again, you have to consider the other statute, 42.013 says, if the case involves, it uses the same word, if it does involve family violence, you've got to have an affirmative finding on the record. Otherwise, the defense attorney has no opportunity to object because you don't know that it's going to be a finding and you don't know that it's going to hurt your client later on. So that's the whole point of making it clear on the record, this is family violence. There's special rules applied to this case. So It does say involve in that language, not just there has to be a finding just in general, but it says if it does involve it, there has to be a finding. No finding means de facto position. It did not, quote unquote, involve family violence, not at least for official legal purposes.
Okay, your interpretation is not what Ms. Bowen just read out of the book on 411-74. Is that correct, Ms. Bowen?
Correct.
Would you read that one more time for us, Ms. Bowen? There are two paragraphs, Mr. Gordon. That's where I'm hung up. One says if there's an affirmative finding of family violence. We don't have that here. Everybody's in agreement. So you go to the first paragraph that just says if it was initially a family violence case or words to that effect. Ms.
Any
Bowen?
other offense involving family violence.
Right. And I understand why you're getting hung up on that, Your Honor. If I can just try to address it one more time.
Sure.
I understand she's saying it's an either or proposition. Okay. And if you read that statute in isolation, I can understand where she comes from. But again, if you read the other statute, it says, and the other statute tells you, how do you determine if it even involves family violence? How do you determine that? Is that just random? Can any judge just randomly say that? Does there have to be facts? No. The statute says if it does involve it, there has to be an affirmative finding. So they're basically linking the two together. That is how you know that it did involve family violence officially, according to the statute, is that there was an affirmative finding. So even though the other statute kind of hints like, oh, it's an either or proposition, the only real way to know, hey, is this family violence or not, is to look at the other statute. And it says, if it involves family violence, there will be an affirmative finding. So actually that statute links them together. It can't just be one or the other. And there's no other way to officially determine it, unless Your Honor wants to have a hearing on every one of these cases from here on out, where you let them testify that the affidavit said one thing and the police report said one thing, and that they can just win automatically based on any mere allegation of family violence. That's what their standard is here today.
Well, Your Honor,
go ahead.
we haven't been before the court very often, so I think it doesn't come up very often.
Well,
okay.
Maybe nobody pushed it like me so far, but in either case, I do think that it leaves it all open-ended, and that there's a simple way to determine whether it's family violence that doesn't require any subjective, after the fact determination. You just look at the record. And the statute I quoted says, if it involves it, there has to be a finding. No finding, de facto, by default, means it didn't, quote unquote, involve it.
Well, that's not true, Mr. Gordon. I just explained what our policy is. If they're on deferred adjudication probation, in our court, there's never a finding of family violence. Okay? If they successfully complete deferred adjudication. That doesn't mean it didn't start out as a family violence case. That just means the defendant did well on deferred adjudication probation, or he had a very good lawyer like you that helped him get to that point. But under the law, as y'all provided me, and under the facts that Mr. Berry testified to, there's no doubt in my mind this originated as a, quote, family violence case. I may not agree with the definition of family violence under the family code or the code of criminal procedure, but if we're going to follow the law, it initiated as a family violence case, quote unquote. So that's where I'm hung up, and that first paragraph kicks in, and he's not eligible for a finding for a non-disclosure order. That's my position at this point. In the nicest possible way, I'm ruling against the petitioner and ruling for the state. But if you have any other evidence that you want to put on that would show that this is not originally a family violence case, we'll be happy to hear it now or at any future point, whatever you want to do.
Judge Christian, is there a police report?
I don't know, sir. I'm sure there is, but who knows? This is a long time ago.
Hey, Jason, I think
Before I rule, Mr. Gordon, if you want to go find a police report,
Mhm.
I'll be happy to give you time to do whatever you want. Ms.
Yeah.
Bowen and I are going to be here regardless, whatever you do and wherever you go. So
I
I can
did-
defer ruling until you go get a copy of the police report. Is that something you'd like to do? That's a good idea, Mr. Berry.
Well, I was told the DA was going to get it.
I can clear it up, Your Honor. I actually did pull up a copy of a police report. I don't think it's going to change your ruling. I mean, it does state that he assaulted this young lady. So if that, I don't think that would change your ruling. So
okay.
I obviously disagree with it, but I appreciate you giving us a lot of time to at least argue the issue, Your Honor. Appreciate you taking out of your busy schedule and allowing us to thoroughly argue the issues back and forth. I obviously wish you ruled in my favor, but I understand.
Okay. Good luck, Mr. Berry. Thank you, Mr. Gordon. Thank you,
Thank
Ms.
you.
Bowen.
Thank
Who's
you.
going to prepare an order? Ms. Bowen is going to prepare an order, or Mr. Gordon is going to prepare an order? Who wants to do that?
I guess I just assumed we would just leave it with, if Mr. Gordon would, I don't know, Your Honor. I'll get an order. Or,
Okay.
All right.
Thank you.
Thank you, Your Honor.
Thank you very much. Good luck, sir.
Thank you. Bye-bye.
Okay. Break. Back on the record on State of Texas versus Gene Zenard Mooney Jr., clause 638793. Mr. Robinack, where are we at?
Sorry, Judge, I was muted. Well, so I understand they're going to be waiving the new number ones and the other related things, and they want to proceed on the other allegations. They say that the time is always left up to you. You generally tell me what type of things you do. What do you sentence people that are facing technical allegations to if they're found true?
He's probably got an underlying of 1 year. Is that correct, Susan?
He is on deferred adjudication.
Oh, okay. Then he's on deferred.
Your Honor, he also has a new case with us.
He's got several of them. In these situations where there are new cases pending, as a standard operating procedure, the defense counsel always has them plead not true to those allegations because they haven't been proven. Would that be accurate, Mr. Bravanek?
True.
Okay, so that would be not true to those, and that'll be worked out in another court somewhere down the line. So we've got a failure to submit to drug testing, failure to obtain gainful employment, possess contraband in his vehicle, which I assume is some sort of drug, purchase, receive, possess, or transport a weapon, namely a handgun, fail to register for the DOEP program, fail to register and attend gun safety court. I'm not going to rule in advance before I hear any evidence and whatnot, but obviously he's on probation for one of the most serious crimes in a misdemeanor trial court of unlawfully carrying a weapon, to wit a handgun, and he allegedly had another handgun with him which violated his probation, and we're not getting concerned with all these other new charges and whatnot. So now I would have no problem whatever I decide running it concurrent with, if he gets revoked, all these other cases, if that becomes something that would be an issue.
Well, so let me see what he wants to do, and I'll get back to you.
That'd be fine.
All right. Can you send me a breakout room, please, Pat?
Of course.
Microphone is turned off, Pat.
I apologize. I hit the wrong button. So hold on. Let me get you into 2 and